LexisNexis is one of those major credit bureaus that nobody ever talks about. You should always be disputing with LexisNexis instead of the main three that are known: Experian, Equifax, and TransUnion. LexisNexis is going to show all your inquiries ever made. And LexisNexis is going to show all your hard inquiries, your soft inquiries, all the good stuff, right? I don't care how long it's been, they pulled it. Okay, so you highlight your soft inquiries, hard inquiries, whatever you need to do. We're talking about soft inquiries in this TikTok thing, so highlight all your soft inquiries. Then you're going to go ahead and drop your letter. Your letter is basically going to say you are in violation of the Credit Reporting Act, 15 U.S.C. 1681, for unlawfully obtaining my Equifax, Experian, and TransUnion consumer report on the date. Your LexisNexis report will show the date without my authorization and permissible purpose under the FCRA. As a result of you unlawfully obtaining my consumer report without my permissive approval, you are liable to me actual damage or statutory damage about up to $1,000 in punitive damages. Now, remember, when I was on the phone with Discover, they said that I was not approved for whatever. They tried to check my credit. My credit was froze, so how can you determine to make a decision if my stuff was froze? Had y'all asked for my permission, I would unfroze it so that way you can see my credit report so I can get the credit increase. So anyway, so they caused me damage. I'm willing to settle this matter without admitted liability. Cease and desist. I'm obtaining copies of my consumer report from the Consumer Reporting Agency. Pay me $1,000 and deliver it to my address above within the 14 days of receiving this demand, or increase my credit limit in the amount of $1,000. I'm not trying to be greedy. I really just wanted a credit increase, so that's why I put or extend my credit for that $1,000. Please be advised, I am prepared to place a commercial lien on your company if you do not comply with this demand. Upon time of receipt of the $1,000 payment and credit increase, this letter shall be general release of all claims herein. Okay, so that's what I put. I would not, if you are not privy to, secured party creditor and discharging debts, I would not put commercial lien or anything like that. Send off certified mail. Go ahead and upload a copy to CFPB. They also said FTC, but I have not figured out FTC, and I never really needed FTC. But I'm learning that FTC is quote unquote big, so you can send it to them for a copy, and that's pretty much it. Wait 2 weeks, and Discover is 2 weeks. I didn't have any problem. They just sent me a check. Okay, I don't know how y'all get this information within 3 minutes, but let's go. Okay, let's go to the inquiries. I'm not even talking about a hard inquiry. I'm talking about a regular old soft inquiries. Those ones that they don't want you to know that they're pulling. So let me show you this. This is my check that I got from Discover. Because why? They pulled my consumer report without my permission. 15 U.S.C. 1681B has a permissible purpose. You can go look it up yourself. I think I did a video about it previously, but this also includes soft inquiries and hard inquiries. How can you tell if there was a soft inquiry? You can go to LexisNexis, pull that, it'll have a list on there. Now, Discover actually messed up and just physically told me whenever I called to get an increase. So that's how I knew that they pulled it, because they accidentally told me that they pulled it without my permission. So y'all, go get your money, honey. It's a $1,000 violation. Get your money. Now, how do you go about it? It's just a simple letter. What they actually did is they gave me $1,000 back in a check, and they actually increased my line $1,000. I had no clue. I was gonna go tit for tat. I was busy, and they did it within 2 weeks, and I got my money and my increase. Now, what you do is simply just write a letter. Hey, Discover or whatever credit card company, whatever it is, I've noticed you pulled my consumer report without my permission. Tell them the law, 1681B, and you have these 3 descriptions, and that's pretty much it. You guys, I just made it up as I went. I didn't have no template or anything like that. I said what I said, whatever came to my mind, exactly what they did. I know what 1681B says, and I just wrote what was in my brain. I didn't use a template or anything like that. But get your money. Y'all have money. Get your money. All right. I don't know why people
June 24, 1975. Appeal from District Court, Texas County, Merle Lansden, trial judge. Bank brought replevant action against Appley to recover possession of automobile pursuant to terms of security agreement. While action was pending, Bank obtained possession of automobile, and it was sold. Trial court found Bank was not entitled to possession of automobile, and Appley was entitled to recover its value. Jury returned verdict finding value to be $3,000. Trial court entered judgment for Appley for that amount, plus costs and attorney fees. Bank appeals. Affirmed. Lamar, Tryon, Sweet, Field Petty by Larry L. Field, Guyman, for appellant. Ogden, Ogden Board, Guyman, Benefield, Shelton, Lee Wilson Tyree by Jim W. Lee Charles the 50th, Freed, Oklahoma City, for Appley. Barry, Justice. This is appeal from trial court's judgment and replevant action. First National Bank of Amarillo filed replevant action against Robert the 50th, LaJoie Appley. It alleged right to possession of 1964 Chevrolet Corvette pursuant to terms of security agreement executed by Appley. While action was pending, Bank acquired possession of Corvette and it was sold. Appley filed answer and cross petition alleging Bank's security interest was void and requesting Corvette, or value thereof, be returned to him. After hearing Bank's evidence, trial court found Bank's security interest in Corvette was void under 14 AOS 1971 Section 2407, 14A to 407, and Appley was entitled to recover its value. The question of value was submitted to jury, and it returned verdict for $3,000. Trial court entered judgment awarding Appley $3,000 plus costs and attorney fees. Bank appeals. Subject to exceptions not herein applicable, Section 2407, supra, prohibits seller in consumer credit sale from taking security interest in property other than property sold. It provides in part, 1. With respect to a consumer credit sale, a seller may take a security interest in the property sold, except as provided with respect to cross-collateral, Section 2408. A seller may not otherwise take a security interest in property of the buyer to secure the debt arising from a consumer credit sale. Message. 3. A security interest taken in violation of this section is void. Bank's evidence indicates its security interest arose out of transaction which occurred on November 24, 1972 in Amarillo, Texas, wherein Appley purchased a 1973 Chevrolet Vega from Chevrolet Plains. Plains and Appley executed instrument entitled Motor Vehicle Retail Installment Sales Contract in Security Agreement. Bank's name is printed at top of agreement form. However, form designates Plains as seller and Appley as purchaser. In agreement, Appley agreed to pay 36 monthly payments of $132.29 and granted Plains security interest in the Vega and Corvette to secure payment. Payments were payable at bank. The agreement contained provisions entitled Non-Recourse, Assignment, and Repurchase Agreement. On November 29, 1972, Plains executed these provisions assigning its right in contract and property described therein to bank. In repurchase agreement, Plains agreed to pay unpaid balance in event bank repossessed property and returned it to Plains. Bank's evidence indicates it buys thousands of contracts from Plains each year. When Plains salesman and customer agree upon credit sale, Plains credit manager calls bank, and bank checks purchaser's credit. Bank then telephones and states whether bank will give credit and conditions thereof. Purpose of this is to ensure bank will buy contract after Plains executes it. On this occasion, bank imposed requirement that Appley have larger down payment, additional collateral, or cosigner. Plains credit manager related this information to Appley, and Appley offered Corvette as additional collateral. Parties then executed agreement and Plains sent papers to bank. Appley has never been in bank. All papers were prepared at Plains, and contract was signed by Plains and Appley. However, Appley knew contract would be financed at bank. Bank subsequently repossessed the two automobiles and returned them to Plains. Plains paid bank pursuant to repurchase agreement. Bank also introduced financing statements executed by Appley as debtor and bank as secured party. These financing statements recognized bank had security interest in Vega and Corvette. After hearing bank's evidence, Trial court found transaction between Plains and Appley constituted consumer credit sale as defined by 14 AOS 1971 Section 2104, 14A to 104, that even 14 AOS 1971 Section 2104, 14A to 104, that even though contract executed in Texas, provisions of Section 2407, supra, were applicable and security interest in Corvette was void, that bank was assignee of Plains rights, and bank did not have valid security interest in Corvette. Section 2407, supra, applies only to consumer credit sales as defined in Section 2104, supra. There is no similar prohibition applicable to consumer loans as defined in 14 AOS 1971 Section 3104, 14A 3104. Bank first contends trial court erred in finding transaction between bank and Appley was consumer credit sale rather than consumer loan. 14 AOS 1971 Section 2104, 14A to 104, 1, provides that, except as provided in subsection 2, consumer credit sale is sale of goods, services, or interest in land in which credit is granted by person who regularly engages as seller in credit transactions of same kind, be buyer's person other than organization, c the goods, services, or interest in land are purchased primarily for personal, household, or agricultural purpose, d either debt is payable in installments or credit service charge is made, and e with respect to sale of goods or services, amount financed does not exceed $25,000. Section 2104, 2 provides unless sale is made subject to act by agreement. Consumer credit sale does not include sale in which seller allows buyer to purchase goods or services pursuant to lender credit card or similar arrangement. Bank admits transaction between Appley and Plains constituted consumer credit sale. An installment sales contract was assigned to it. It argues after Appley selected car, Plains and Appley contacted bank requesting loan, that sale of Vega was complete at that time and application for loan was second transaction. It contends it rejected application and only accepted it after additional security was offered, and contends this arrangement constituted loan between it and Appley. If Appley had borrowed money from bank to purchase automobile, and then used proceeds of loan to purchase automobile in cash transaction, the transaction between bank and Appley would probably be held to be a loan. See People's Finance and Thrift Company of Ogden v. Perry, 30 Utah, 2D 282, 516 P 2D 1400. However, in present case Appley dealt only with Plains. He entered installment sales contract referring to him as purchaser and Plains as seller. He did not execute a note or any instrument of indebtedness with bank. Bank took assignment of Plains rights under contract. After Appley defaulted, bank repossessed automobiles, returned them to Plains, and Plains repurchased sales contract from bank by paying bank amount of unpaid balance. We conclude only inference which can be drawn from these facts is that there was no consumer loan transaction between Appley and bank. The transaction between Plains and Appley was consumer credit sale, and bank was merely assignee of Plains rights under sales contract. Bank next contends court erred in ruling it was improper to take additional security in a consumer transaction. Under this contention, bank first argues transaction between it and Appley was consumer loan. Since we have previously determined there was no loan by bank to Appley, we need not consider this contention. Bank further contends trial court erred in refusing to take judicial notice of Texas statutes relating to this transaction. This argument implies security interest was valid under Texas law. 14 AOS 1971 Section 1201, 14A 1201, 5, provides in part. 5. If a consumer credit sale is made in another state to a person who is a resident of this state when the sale is made, the following provisions apply as though the transaction occurred in this state. Be a seller or assignee of his rights, may not enforce rights against the buyer with respect to the provisions of agreements which violate the provisions on limitations on agreements and practices. Part 4. Appley was resident of this state at time sale was made. Seller's assignee brought replevin action to enforce its security interest in this state. The provision of security agreement granting seller security interest in Corvette violated Section 2407, supra, one of the provisions on limitations on agreements contained in Part 4 of Oklahoma Consumer Code. Section 1.201(5) of Uniform Consumer Credit Code is identical to Section 1-201(5) supra. Comment 1 thereto states, this section allows the enacting state to apply all of these protective provisions to its own consumer residents when enforcement actions are brought against them in the enacting state. We conclude this contention is without merit. Bank further cites 14 AOS. Sup. 1974 Section 112, 14A to 112, which authorizes seller in consumer credit sale of motor vehicle to secure debt arising from sale by security interest in other motor vehicle used for purpose of transporting persons or property, as well as motor vehicle which is subject of sale. We conclude that section is not applicable because it was not adopted until after trial of present case, and parties did not follow procedure set out therein. Bank further argues Section 2407, supra, does not prevent assignee of seller from taking additional security from buyer. In support of this, it refers to 14 AOS 1971 Section 2408, 14A to 408, which provides in part, seller in this section does not include an assignee not related to the original seller. It then contends this definition of seller should be applied to Section 2-407, supra, and Section 2-407 should then be construed to permit assignee of consumer credit sales contract to take additional security. If Section 2407, supra, were construed as bank contends, it would not aid bank in the present case. Here, Plains, as seller, took a security interest in the Vega and Corvette. Bank did not take a security interest in anything, but merely accepted an assignment of Plains' security interest. Plains' security interest in the Corvette was void under Section 2407, supra. We find no authority which would allow this void security interest to become valid when assigned to bank. 5B Bender's Uniform Commercial Code Service Section 92B.33 considers provisions of Uniform Consumer Credit Code, which makes certain agreements void, and states, certainly any provision in the credit agreement, which is unenforceable or void is equally so against either the original creditor or assignee. Furthermore, in numerous cases, we have held assignee of conditional sales contract stands in shoes of his assignor, and defenses which vendee would have against assignor are available against assignee. Hudeberg Imported Cars, Incorporated. V. Hart, Akla, 383 P2D 650. National Bank of Commerce of Tulsa v. ABC Constable. Company, Akla, 442 P2D 269. We conclude the only reasonable inference which can be drawn from bank's evidence is that Plains' security interest in Corvette was void under Section 2407, supra, and that bank, as Plains' assignee, was not entitled to enforce it. In numerous cases we have held where plaintiff's evidence in replevin action affirmatively shows that defendant, and not plaintiff, is entitled to possession of property involved, there is no issue of right of possession to be submitted to jury, and the cause may be submitted to jury only upon issue of damages claimed by the parties growing out of the wrongful taking of replevin property. Oliver v. Leslie, 207 Akla. 155, 248 P2D 624. Peace v. Golightly, 168 Akla. 582 35 P2D 469. We conclude trial court properly limited jury's consideration to issue of damages. Bank further contends trial court erred in denying motion for new trial due to excess of damages. In support of this contention, bank cites evidence Corvette had 90,000 miles on it when Appley purchased it. Appley only paid $2,000 for it. It was not in running condition when bank repossessed it. Plains subsequently sold it for $600, $700. And Appley only sought $2,400 in original petition. Bank introduced no evidence concerning Corvette's value. Its witnesses did testify that after bank took possession, Plains sold it wholesale for $600, $700. Appley testified he paid $2,000 for Corvette, installed racing equipment on it, and invested $7,500 in it. It was in good condition and he could have fixed it for $125. In his opinion, it was worth $4,000 on date Bank took it. Ronnie Carden testified he is drag racer, is familiar with value of Corvettes in area, and was familiar with Appley's Corvette. In his opinion, it was worth $3,500. The amount of verdict was within permissible limits reflected by evidence. Where evidence is conflicting as to amount of damages suffered, it is for jury to determine amount thereof from all competent Incorporated. V. Hart, ACLA, 383 P2D 650. National Bank of Commerce of Tulsa v. ABC Constable. Company, ACLA, 442 P2D 269. We conclude the only reasonable inference, which can be drawn from Bank's evidence, is that Plain's security interest in Corvette was void under Section 2407 Supra, and that Bank, as Plain's assignee, was not entitled to enforce it. In numerous cases we have held where plaintiff's evidence in replevin action affirmatively shows that defendant, and not plaintiff, is entitled to possession of property involved, there is no issue of right of possession to be submitted to jury. The cause may be submitted to jury only upon issue of damages claimed by the parties growing out of the wrongful taking of replevin property. Oliver v. Leslie, 207 ACLA. 155, 248 P2D 624. Peace v. Golightly, 168 ACLA. 582 35 P2D 469. We conclude trial court properly limited jury's consideration to issue of damages. Bank further contends trial court erred in denying motion for new trial due to excess of damages. In support of this contention, Bank cites evidence Corvette had 90,000 miles on it when Appley purchased it. Appley only paid $2,000 for it. It was not in running condition when Bank repossessed it. Plain subsequently sold it for $600, $700, and Appley only sought $2,400 in original petition. Bank introduced no evidence concerning Corvette's value. Its witnesses did testify that after Bank took possession, Plain sold it wholesale for $600, $700. Appley testified he paid $2,000 for Corvette, installed racing equipment on it, and invested $7,500 in it. It was in good condition and he could have fixed it for $125. In his opinion, it was worth $4,000 on date Bank took it. Ronnie Carden testified he is drag racer, is familiar with value of Corvettes in area, and was familiar with Appley's Corvette. In his opinion, it was worth $3,500. The amount of verdict was within permissible limits reflected by evidence. Where evidence is conflicting as to amount of damages suffered, it is for jury to determine amount thereof from all competent evidence before it. And if there is any evidence reasonably tending to support verdict, same M.
Sauce. This one's a long one, but you know all these long ones is fire. So check this sauce out. Run that shit.
Is
Focus.
held to
Pay attention.
in terms of understanding
Ask
the
the
law
right
and procedures
questions.
of court if you choose to represent yourself.
I object again. Is the court using my bond? Where is the appearance bond? And the bid bond? I do not understand. I do not comprehend. And I would.
See how everybody got quiet when he said that? Everybody got quiet. They started talking about bid. That's what will happen when you kind of sideswipe them like that. I request that they produce the bid bond on this matter. See, one of the things that they're not going to do is they're never going to lie or deny something. They're going to use obfuscation. All right? They're going to figure out a way to get around it. They won't directly deny what you're saying. Start paying attention to that.
Take notes.
It's going to be obfuscation is the tool that they use. and just run over you and make you look stupid and do things like that. You have to prepare for court. You got to be prepared. You have to anticipate almost. If you're going to go into court, you need to have the ability to anticipate how they're going to respond to you and what you're going to say in response to that.
Where is my bond? I need my bond back. I need my big bond. I'll write one and overnight it. Where's my bid bond? And who is the highest bidder of the case?
All right, on
Crickets.
this case, State of Washington versus Mohammed Ismail Idris, case number 3A0257.
Do you see how he just handled that? I ignored him. That's why I come in. You have to ask him 3 times. Ask for the bid bond. That's what I get here is silence.
3 times.
I don't even care if it's not, if it ain't even in court. I could be speaking to an attorney, and they hit him with the bid bond. He gets silent. That bond is what Gene Keating was talking about. It's a bid bond. They form a bond. See, the reason why is there a bond? Okay, this is for everybody listening. There's a bond because the statutes represent a charge. A charge is a lien. A charge is a lien. Let's look at that real quick. Look at that real quick. What is a charge? What are charges? When somebody puts some charges on you, you have to stop and think about what that word means, what a charge is. Let's look at it real quick and see if we can get some insight into this word charge. All right, so back to our trusty Black's Law Dictionary, 8th edition. Let's go to the C's. Let's look up this word charge. Here we go, charge. Okay, charge.
Focus.
A formal accusation of an offense is a preliminary step to a prosecution, a murder charge. Okay, we all familiar with that, the general term, but look how many senses of the word, look how many different definitions of the word charge we have. How do we know what meaning they are using when they call we're getting a charge? It says an instruction or command, all right, jury charge. Okay, review the charge for appealable error. 4, an assigned duty or task or responsibility. But here's the one, an encumbrance or lien or claim. So if somebody's putting a charge on you, could they be having a claim against you? And if they have a claim against you, so if, let's say they're possession with the intent to distribute, that's a charge. Well, there's an amount associated with that because it's dealing in commerce. This is where the debtors' prisons came from. Under Edward I, with the statute merchant, in case you're wondering, well, where did this come from? It's not nothing new. They've been doing this for the last 1,000 years.
Since the beginning of
So
time.
a charge, possession with the intent to distribute, okay, that's $1 million charge. They don't tell you that, but it's $1 million on the books. It's showing in accounts receivable. So when you come in and you start arguing, they say, okay, well, you don't want to pay the debt. You are an absconding debtor. So we're going to hold your body, and then we're going to take this debt, convert it into a bond, and sell it. Now you get an indication of how the government is funding themselves. Because they'd already told you that all your taxes, the 100% of the Reagan, you did the investigation, and 100% of y'all taxes get just paid on the interest. So how's government funding themselves? They having to make money through charges. That's why you see this mania for writing you traffic tickets. Little thing. Because money is created off of debt. So one of the rules is there is no money. The reason that's the number one rule, because everything in our system today revolves around that fact. That since there isn't any money, debt is being used as money.
Guys.
So everybody is looking for an opportunity to create money by creating debt. Debtors' prisons.
So with that being said, the dollars we spend, the fiat money, It's fake. It's all fake. Remember that. It just buys us things, but it's really fake. Real currency is gold and silver. That's how it is. Good day to you.
Traps in the DS-11 form. Department of State likes to sabotage the passport.
To let you know about my series that I put together. It's just basically one video teaching you how to file your DS-11 for your status correction. Some people call it a 5-star passport. There's controversy behind that because you don't always get 5 stars. Some people get 3, some people get 4. But ultimately, it's what happens when you deal with the police after you correct your status and no longer accept liability as a U.S. citizen, because the U.S. citizen technically only exists on paper. And if you were to do a Freedom of Information Act with Homeland Security, asking them if there's any documents that are relative to you being a U.S. citizen, they'll send you back a letter that says there is not. So there's proof enough that you are not a U.S. citizen. Because a U.S. citizen is a political entity, and any political entity is fictional and only exists on paper. Just like the state that you live in, it's an imaginary line. It's a body politic, but it's an imaginary line. It's a political entity. So a U.S. citizen is a political entity who submits themselves to the dominion of the government for the promotion of the general welfare and protection of the individual as well as collective rights. U.S. citizens don't have constitutional rights because they only exist on paper. How could they? But they also, one thing to pay attention to, and that is the dominion. Dominion is right of ownership by claim and disposition in a law dictionary. So I don't think any of us have submitted to be dominated and owned by our government. And furthermore, the reason that is so is because when your parents signed a birth certificate, then the whole U.S. citizen was created because that allowed our government to do commerce in your name, which is your name in all capital letters, which you will see on your birth certificate, your driver's license, your vista bill, and things like that. So the government does own that entity. They created it. We allowed them to create it, or our parents did at least. But there's things that go along with that. Things as far as the Siesta Cuevi Trust that was created, and the account that collects money your whole life that you can actually receive benefits from as long as you handle the accounting for that estate as the surety to the estate. So because it is a fictional entity that only exists on paper, so it can't sign any documents. So therefore, you need to handle the accounting. And so in doing so, if you learn to operate between the public and private and learn what applies to you and what doesn't, how to endorse things, then the world becomes a whole different game. And truly, common law is the only thing that would then thus apply to you. And that's the ultimate goal, is to get back to that freedom of common law, right? So anyways, part of that is the DS-11 filing for the passport, and filing that properly so that you create the separation between you and the U.S. citizen, because you'll file as a non-citizen national, and there's other things that you'll have to do on the document properly so that it will get recognized as such. And so anyways, that's what it's all about. The thing about it is the 5-star passport, you're going to get between 3 to 5. That doesn't mean your status wasn't corrected. For whatever reason, they felt like, that they're not going to give you that full clearance yet. And there's different things that you can read about, if you have cases in court, or court cases, if you have warrants, if you have all these different things, right? Sometimes, I've read things of people making their court cases go away or their warrants go away by filing the passport this way. I personally, in my own story, have, after I did it, the cops, because what you want to do is, once you file, you basically want to create separation between you and that old entity that you accepted liability for as a U.S. citizen. So any address or phone number or anything that was tied to you before that, bank accounts, anything like that, you're going to want to change everything, because you're no longer going to use state IDs. You'll use your passport ID, and basically you'll become a ghost in their system, and they won't be able to find you. They're going to be scratching their heads. At least this is what I experienced, and they couldn't find me anywhere in their systems, and that's kind of what the ultimate deal is, right? You don't want to be part of their system. You want to be outside of that. So then, you could take it farther and learn to operate behind a trust and do all those different things that, we do, and then virtually become a ghost. And then you'll just have to act as surety to the estate for the U.S. citizen. And, virtually, when you start learning these things, you can get rid of court cases by endorsing or filing 1099s. There's different ways of doing things, but ultimately, if you learn how to operate and do all these things, you will virtually be able to, any statutory case, get rid of. We're truly the only thing that applies to is common law. But you can live as a ghost, because if you operate out behind a trust and things like that, the trust has its own EIN. You could call and get your power and everything hooked up. And truthfully, I probably shouldn't leak this out there too much, but if you ruin the credit on a trust or even an LLC, because it has its own EIN as well, so you could essentially get rid of that and create a new one. You'd have fresh credit all over again. And so you could, if you screw up a couple times, and you don't necessarily need to file bankruptcy, your business might if you want to keep the business name. But you could create entities, and if you screw that one up, it's credit and stuff, you could scrap it and get a new one if you actually really wanted to. But those are other things that we could get into later down the line. Right now, we just want to focus on getting the status correction done through the passport filing. And this little video is to let you know there should be a link. That's what this is all about. There should be a link somewhere in here or wherever that will lead you to the video. They won't let me actually show you. I've tried to make this video several times and actually show you the DS11 form and show you whatever, to put whatever, but they won't let me do it that way because it's personal information on the document. So basically what I do is I just talk you through it, guide you through what you need to put in what lines, and then where you need to set your appointment at the post office and how to deal with that. You got to make sure you have your birth certificate ready because you'll have to send that off with your DS11 form and all those things. So, yeah, I mean, it's crazy because even when I look at my tax forms and everything now, because I don't pay federal taxes. After I did this, I filed the W-8BEN to claim as a foreign status to the United States, and it lists me on my tax forms as a non-statutory employee. So, there is a lot of truth to the things that you hear. There's a lot of misinformation, but there's a lot of truth as well. And if you just, keep your sensibility about you and keep on the path, you'll get there. And things will change. And it's incredible. It's incredible. So, anyways, hit the like, hit the follow. If you're interested, the video is $49.99. TikTok's going to take $15 of that. So I'll get.
An irrevocable trust is an agreement allowing property to be held by one party for the benefit of another, stipulating that it cannot be readily revoked, altered, or amended. It's commonly used for asset protection and estate planning purposes. A trust is a legal tool that consists of a settlor who has the trust created, a trustee who manages the trust, and one or more beneficiaries who receive the benefits of the trust. You'll also hear a settlor referred to as a grantor or trustor. Then the next question we answer is about revocable versus irrevocable trusts and how they compare. I've been in the asset protection business since 1991. I believe we have over 65,000 clients in our database and have established literally thousands of trusts and companies for other law firms, accountants, and members of the general public. Revocable versus irrevocable trusts. A revocable trust, commonly a revocable living trust, is an estate planning tool that a settlor can change at any time. So if your needs change, you can make amendments freely without the interaction of a third party. So why doesn't everybody set up a trust that's revocable as opposed to an irrevocable one? It's because the living trust is part of your estate for tax and asset protection purposes. So a revocable trust offers little protection from creditors or those who seek to sue you. It also offers no segregation of assets in order to qualify for Medicaid assistance. Plus, upon your death, such a trust is also yours for state and federal tax purposes. So why irrevocable? The primary reason people use irrevocable trusts is to protect assets from lawsuits. Legal theory commonly allows a creditor to step into the shoes of the debtor. It allows the creditor to do what he or she could do. For example, let's say a settlor of a trust could freely change the beneficiary. The one who sued the settlor could step into his or her shoes and change the beneficiary to himself. If the trust allowed the settlor to independently spend trust assets on himself, the creditor could step into his shoes and do the same. Plus, some people use irrevocable trust to make sure that others carry out their wishes when they are no longer around. And this is common in a second marriage where a spouse wants to make sure that the children from the first marriage get at least some of the assets. So can I ever change it? Well, mom and dad unexpectedly have another child. One child exhibits evidence of long-term substance abuse. One child has a tragic military accident.
It's not the right video.
But I also learned some other things while on the call. So basically I called and I was just like, hey, I'm preparing a home birth. I just wanted to get some more information in regards to how to apply for the Social Security number, how long the processing time is, what the application looks like, and find out if you could tell me when mine was issued to me. I added that part in later. So she's like walking me through like what the application looks like, what documents I need, who can get it. She was talking about how I should hit up vital statistics, vital records, and ask them any other questions that she couldn't answer. And then I was talking about like my birthing plan. I told her I was 4 months pregnant. And I told her that I was creating a family book for myself. I was talking about how I wish I could ask these questions to my father, but he's passed away, which is true. So RIP. And so we were talking, and she basically answered all the questions, and then I could tell she was hesitant, like she didn't want to tell me when my number was issued to the taxpayer, because she was like, it's useless information, you don't need to know that. But I persisted on. I was like, well, can you just please tell me like what my file says? And she basically told me that you can request what she described as a master file, but she didn't describe it. She didn't say the words master file. She said it's a file of your complete work history, and it's $180. And then she said you might be able to download it online for free. Anything online is free. And then I asked her if she could look up information, my records, like my master file. If she could just look it up and tell me when my Social Security card was issued to the taxpayer, because I would like to put it in my book. And she was like, okay, well, what's your Social Security number? What's your name? What's your date of birth? What's your address? What's the address that you received benefits from when you were 18? I'm like, 18? So I'm reading the address on my birth certificate, and she's like, that's not it. I'm just like, okay, can I just tell you a few zip codes and you tell me yes or no? Absolutely, she could not do that. So I had to name every single address I've ever lived at in the past 12 years, which was hard because she's like, that's the wrong zip code. So I'm literally having to Google my old addresses, because who remembers that shit? You know how many places I lived at? Try to find me, okay? Because I don't even know the address. So finally gave her the address, and then she proceeds to tell me the date it was issued to me. Well, to the taxpayer. So that was really awesome. So then I was like, thank you so much. I really appreciate it. So then I start asking her questions about the birth certificate. And I also kind of set it up in a way. I was like, I just don't understand all 3 dates on it. Like, obviously it's the day I was born. There's also a date signed and a registrar date. Can you explain the different dates to me? And she basically said, well, obviously the date you were born is your birth date. And then the date it was signed was the date the doctor signed your birth certificate. And then the date for a local registrar is the date that the doctor and the hospital submitted your paperwork to the state. I was like, oh, that makes so much sense. I just really never had anyone break it down like that for me. Maybe I have, I don't know, I black out, so who knows. But then I start asking her questions like, well, since I was born in Georgia, does that make me a Georgian? Like, how would I be a U.S. citizen? And what's the difference? What is a U.S. citizen? She literally said, a U.S. citizen is somebody who's born in the United States, citizens abroad, or a U.S. territory. So I was really breaking it down. But then I was like, so I've also been looking at Ancestry and trying to find out if I'm anything part Indian, whatever. And she was like, she knew exactly what I was talking about. I was like, can you be a citizen of the United States and part of the tribe at the same time? She doesn't know. She told me to contact Tribal Registry of Native American Affairs, Indian Services. So Nonetheless, I got her done. So now I gotta call the IRS and get my taxes. We need that to put on my form to mail out at 5 p.m. Oh, I also wanted to tell you another little fun fact. So I did not know this, and I was actually kind of like, it kind of blew my mind when she said this, and it didn't even register until she said it again. She said, because I was asking why so much time had passed between the time I was born and the issuance of the Social Security number. And I was like, is there anything I need to be worried about for the time in between? Like, what does that mean? And she was like, no. You can apply for a Social Security card or Social Security number anytime from the date you were born until your first job. So I thought that was crazy. Like, what if you never fucking work? Are you just never gonna have a Social Security? Like, that's just a crazy concept. Obviously, it's indoctrinated thinking, but like, that's wild. I never really put two and two together like that. So, and here you go. Y'all, I deserve a pat on the back because I called the Social Security Administration office, so you don't have to. I'm just playing. You're gonna fucking have to if you want to figure out when your Social Security was issued to you. But I'm gonna share my
$200,000. So then, is it true you received $200,000 actual cash value from the borrower, plus monthly payments, and then you foreclosed and never invested 1 cent of legal tender or other depositors' money to obtain the promissory note in the first place? Is it true that the borrower financed the whole transaction? Yes. Are you telling me the borrower agreed to give the bank $200,000 actual cash value for free, and that the banker returned the actual cash value back to the same person as a bank loan? I was not there when the borrower agreed to the loan. Do the standard Fed publications show the bank receives actual cash value from the borrower for free, and that the bank returns it back to the borrower as a bank loan? Yes. Okay. Do you believe the bank does this without the borrower's knowledge or written permission and authorization? No. To the best of your knowledge, is there written permission or authorization for the bank to transfer $200,000 of actual cash value from the borrower to the bank, and for the bank to keep it for free? No. Does this allow the bank to use this $200,000 actual cash value to fund the $200,000 bank loan check back to the same borrower, forcing the borrower to pay the bank $200,000 plus interest? Yes. Then, if the bank transferred $200,000 actual cash value from the borrower to the bank, in this part of the transaction, did the bank loan anything of value to the borrower? Well, it's your money. Is it the bank policy to first transfer the actual cash value from the alleged borrower to the lender for the amount of the alleged loan? Yes, it is. Does the bank pay IRS tax on the actual cash value transferred from the alleged borrower to the bank as income? No, because the actual cash value transferred shows up like a loan from the borrower to the bank, or a deposit, which is the same thing, so it's not taxable. If a loan is forgiven, is it taxable? Yes, it is. Is it the bank policy to not return the actual cash value that they received from the alleged borrower unless it is returned as a loan from the bank to the alleged borrower? Yes. You never pay taxes on the actual cash value you receive from the alleged borrower and keep it as bank's property? No taxes paid. When a lender receives the actual cash value from the alleged borrower, does the bank claim that it then owns it and that it is the property of the lender without the bank loaning or risking 1 cent of legal tender or other depositors' money? Yes. Are you telling me the bank policy is that the bank owns the promissory note, which is the actual cash value, without loaning 1 cent of other depositors' money or legal tender, that the alleged borrower is the one who provided the funds deposited loan check, and that the bank gets funds from the alleged borrower for free, is the money then returned back to the same person as a loan, which the alleged borrower repays when the bank never came up with any of its own money to obtain the promissory notes? Am I hearing this right? I give you the equivalent of $200,000. You return the funds back to me, and I have to repay you $200,000 plus interest. Do you think I'm stupid?
All the banks are doing this. Congress allows this.
Does Congress allow the banks to breach written agreements, use false and misleading advertising, act without written permission, authorization, and without the alleged borrower's knowledge to transfer actual cash value from the alleged borrower to the bank and then return it back as a loan?
But the borrower got a check in the house.
Is it true the actual cash value that was used to fund the bank loan check came directly from the borrower and that the bank received the funds from the alleged borrower for free?
For free.
This is true.
Is it the bank's policy to transfer actual cash value from the alleged borrower to the bank and then keep the funds as the bank's property, which they then loan out as bank loans as if they actually owned it and loaned their own money?
It was our money from the get-go.
Yes.
You stole.
Was it the bank's intent to receive actual cash value from the borrower and return the value of the funds back to the borrower as a loan?
Yes.
Do you believe that it was the borrower's intent to fund his own bank loan check?
I was not there at the time, and I cannot know what went through the borrower's mind.
So if a lender loaned a borrower $10,000 and the borrower refused to repay the money, do you believe the lender is damaged?
If the loan is not repaid, the lender is damaged.
Boom.
So is it the bank policy to take actual cash value from the borrower, use it to fund the bank loan check, and never return the actual cash value to the borrower?
The bank returns the funds.
Was the actual cash value the bank received from the alleged borrower returned as a return of the money the bank took, or was it returned as a bank loan to the borrower?
Loan.
As a loan.
So how did the bank get the borrower's money for free?
The Treasury.
That's how it works.
Oh.
No more questions, Your Honor.
That's it, guys. It's fraud. Stop scrolling. Stop scrolling. I got the